everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are continuing with part 2 of the Friends of Amber Heard. Some people have written the appellate court in Virginia with some thoughts they want to share as amici curiae. Friends of the court, friends of Amber, and we reviewed one of these briefs yesterday. And it was very, very puzzling on a lot of levels because I found it very hard to understand where they're coming from. And I've been spending a lot of time thinking about it, actually, since the stream ended, trying to understand where their perspective is fundamentally coming from, because I think it's helpful to challenge our own ideas and to challenge our own perceptions and to challenge our own thinking, and to try to understand where someone else is coming from, because maybe someone else has an idea that's worthy of consideration. And so I've been spending a lot of time thinking about the brief yesterday we read and trying to understand why it seems that they and me, for example, are so far apart. Where is this discrepancy coming from? And I don't want to be unduly reductive about it. I want to try to give credit where credit is due. But I keep coming back to reductive thoughts. They're the only ones I have. It's like I try to go through a thoughtful analysis and I sort of just wind up back in the reductive. And the reductive thoughts are that it comes from a place of men are evil. It comes from a place of misandry. It comes from a place where believe only women. It comes from a place where men are the victimizers. And no matter what a woman says, it can't be questioned, because to question it would be to dissuade people from making up lies or something. Like the police, when they investigate most crimes, are going to at some point question the person reporting the crime because, they're a witness or they might have connection to the crime or whatever. It's like they're obviously a part of the mix, and their credibility is going to be part of the mix of the police trying to determine whether this person's involved, whether they're a witness at all, whether they have made it all up, right? So, and a lot of this is intuitive. And of course, the police also have more explicit training on this as well, but it's also implicit. It's something we do as human beings. And the only way that brief that we read yesterday makes sense is if that sort of idea is to be discarded when it comes to women claiming violence at the hands of men. And it comes from a place of hatred of men. It's the only way for it to make sense. And I've been unable to try to give any other credit beyond that. In terms of thought, it's a very weird proposition to me at this point to say Amber Heard should be believed, because so much of what she said on the stand is, in the literal sense of the word, incredible versus the other evidence, that it becomes a lot of, who do you believe, me or your lying eyes? There's not a lot of ways to bridge the gap between what Amber Heard says and the other evidence. I don't see that. The only way you can do it is basically by saying, well, believe only Amber and pretty much literally ignore everything else, because everything else says that she is at best a exaggerator, and at worst just someone who just makes up shit. So I don't really quite understand this to me, but that were my thoughts yesterday. In any case, we are here to talk about brief number 2 from other friends of Amber. I'm not sure which friends of Amber, because sadly these friends of Amber are mentioned in Appendix B, which I don't have, but that's okay. Other friends of Amber, I'm assuming they are comparable in their sort of mix to the friends of Amber in brief A. I'm assuming it's a similar mix of feminist groups, women groups, individual professors, and so forth and so on. But we will read their brief for all the glory it has. Let's go ahead and get started with whatever this is. So this is an opening brief of the Friends of the Court in support of Amber Heard. Okay. Table of contents, table of authorities, table of media publications, the identity and interest of the amici. The entities identified in Appendix A who have signed on to this brief fall into three primary categories. First, organizations that support a vibrant First Amendment have joined to protect their ability to engage in reporting facts and opinions regarding current issues. Well, as long as you're not making up shit, feel free to report facts. Reporting facts is good. And you have the freedom to report any opinion you like, as long as you make it clear what the facts that are the basis of your opinion are. Right? If you say, here's a whole bunch of facts, here's my opinion, opinions are protected. So tell facts that require them to be true, and tell opinions, but okay. Secondly, civil rights and women's groups have joined to address the significant diminution of reporting abuse against women as a result of this verdict. I'm not even sure how that's possible, because this verdict is what, 4 months old? 5 months old? They've been able to track a significant diminution? Okay. Third, groups assisting persons who have been abused, especially involving intimate partner abuse, have joined to protect their clients from devastating effects of this verdict. What? In addition, respected authorities in all three areas have added their voice to the brief. Okay. Apparently, Mr. Depp has also opposed the filing of this brief. I'm not sure why, because again, it's fairly standard for attorneys to say yes to amicus briefs, but for whatever reason, Johnny Depp's not about that. So, okay, I mean, fine. And even if they're entered, it doesn't mean the court really considers them with any weight. The fact that they're entered doesn't really necessarily mean the court gives them any due. But, okay. The amici are gravely concerned that the verdict for Johnny Depp in Depp v. Heard case against his former wife, Amber Heard, casts an enormous shadow over First Amendment law, defamation as an exclusion of First Amendment goes as deep as you like, but sure. Intimate partner abuse victims' incentives to report abuse by their attackers, don't make up shit, and the ability of Americans to speak out about injustices. I don't know, man. I'm feeling pretty able to speak out about injustices right now. What happened to Johnny Depp was an injustice in terms of the treatment from Amber Heard. Also in terms of the $2 million verdict against him. We've read his legal complaints. Issue 1 is best issue. Issue 2 and 3 don't really work. Issue 4 works as an alternative to issue 1. I think Johnny Depp has it. We still haven't read Amber Heard's brief, so we'll see if she has anything when her brief comes to light. That should be illuminating. If not reversed, this verdict will have profound effects on the jurisprudence of Virginia. What? And further effects on the ability of women nationwide to stand up against their abusers. Why is it the ability of women? Why is it the ability of women to stand up against their abusers? Why is it women? What about the men? What about the men? How does this verdict in any way empower men to stand up against their aggressors? How about them? I would imagine that the verdict for Johnny Depp makes it easier for men to come forward, because they think, hey, maybe it's possible that I'll finally be believed. Maybe people will believe that I'm a victim of domestic violence, and it's not something to be laughed off at a sitcom as a punchline, which it still is, by the way, in media, right? The man as the victim is a punchline still. Even in 2022, even in current year. And maybe this will empower men to come forward and tell their side. Why is that not also a thing of value? Why is it not a thing of value that this might empower men? What about the men, though? The verdict will have a chilling effect on a wide range of commentators. Will it, though? Specifically, the verdict already and will continue to deter women who have been abused by their partners from reporting such abuse, whether it be, among others, mental, psychological, verbal, physical, emotional, or sexual abuse. Will it, though? Will it? And how does it help the men? How's that a factor? Not only was this a highly publicized trial, and thank God for that, because it was highly publicized, because we were able to see what happened, we were able to evaluate the evidence for ourselves from the primary material, namely the trial. Doesn't get much more primary than that. We don't have to look at anyone's secondary sources. We don't have to look at anyone's secondhand reporting. We can look at it for ourselves and evaluate it for ourselves and come to our own conclusions. Or can we? Because those conclusions might be misogyny, don't you know? Yeah. Not only was this a highly publicized trial, but it became a social media sensation, possibly in a manner that was not wholly organic. Sure. You want to bring Bot Sentinel into this? That's fine. It is a common tactic for the abuser to sue their victims for defamation. Is it? Is it common? Okay. Re-traumatizing them and impoverishing them through the legal system. Men are now defending themselves. Oh my God, the men are standing up and saying, hey, you're lying. That didn't happen. You have damaged my character. I have the right to go into court and try to crawl some of that character back from your lies. But men standing up against the lies is bad, very, very bad. Men standing up against the lies is bad, very, very bad, because it might encourage more men to stand up against the lies. And it might encourage men to fight back and fight for their rights and stand up for themselves and their constitutional protections. Oh my God, the world is coming to an end. This problem only worsened during the Me Too movement, and this tactic accelerated during the verdict of the case. Really? Really? It worsened during the Me Too movement? Seriously? Were there a lot of defamation claims made by men during the Me Too movement? I don't remember there being a wide swath of them. I remember mostly the zeitgeist being that women can do no wrong, except if it's the wrong women. So it's not that women can't do wrong, it's that only women can do right, which is slightly better. Only women can do right. Women can do wrong, but only women can do right. So if it's the right kind of woman, we believe her. If it's the wrong kind of woman, not so much. So women can do wrong, although we're not going to say that because that would undermine our belief that women can do right. But men can only do wrong. Was there a lot of defamation cases brought during Me Too? I don't remember that. And the tactic has accelerated due to the verdict of this case. What kind of citation is this? C. Angelin Chapin. What kind of citation is this? This tactic has accelerated due to the verdict in this case. C. As authority, Angela Chaplin. Johnny Depp's playbook won't work for most men. What? What kind of citation is that? You say the tactic has increased, and for the support of that proposition, you cite an article that says the tactic won't work for most men. What? What kind of citation is this? Lawyers have noticed a substantial increase in defamation cases involving domestic violence and sexual abuse in recent years. Between 2014 and 2020, there were at least 100 defamation cases filed by those accused of misconduct, most of them filed after the Me Too movement began. Okay, so many things that I have questions about. All right, first problem I have. Between 2014 and 2020, I'm thinking that the Johnny Depp verdict did not influence defamation cases brought between 2014 and 2020. I'm thinking to myself, and I'm pretty sure that the Johnny Depp verdict did not influence defamation cases filed between 2014 and 2020. Pretty sure. Pretty sure. Second of all, a substantial increase in recent years. Also, I'm not so sure about how the Johnny Depp verdict has influenced things in recent years. Not sure about that one. And in a 7-year period between 2014 and 2020, there were 100 defamation cases. What? In 7 years, there were 100 defamation cases? This is an evil. It must be stopped. 7 years, there were 100 defamation cases. So 14 a year in the entire United States. That's one case in every 4th state every year. One case in every 4th state every year. Oh my God. This is a tsunami. It is a tsunami of cases. It is a tsunami of men filing defamation cases against their accusers. 100 in 7 years. That 14 per year, man. 14 men somewhere every year rose their hand and said, nah, I'm not about that. Wow. I'm sure that is a massive deterrent to the women. I'm sure that is a massive deterrent. The one in every 4 states every year. Somewhere in one quarter of the nation, a man will stand up and sue a woman. Oh my God. Wow. Just wow. This must stop. This must stop, because maybe next year, instead of 14, maybe next year there will be 20. Whoa, 20 maybe. Maybe it'll increase 50% and there'll be 20 per year. Or maybe it'll increase 5-fold. It'll be 1 in every state. Oh my God. The horror show. The horror show. And this is all due somehow to the Johnny Depp verdict. Somehow. Between 2014 and 2020. Okay. Yeah. Oh, we cite Mother Jones. Oh, there's a reputable source. That's good. The argument of Mr. Depp's counsel to the jury relied upon many assertions that are nowhere within the 4 corners of the editorial at issue or reasonably derived. Does it, though? Does it? Also, Amber Heard's credibility is a factor in a defamation case. Yeah. The defamation by implication doctrine has become so unduly expanded in this case, it will lead to numerous meritless attacks on editorials and other publications that claimants will assert contain implied references, regardless of how dubious the implication. Yeah, what did she write? 2 years ago, I became a victim's advocate or something like that. What happened 2 years ago relative to the article? You're the one bringing that to mind. You know, talking about you seeing it yourself and how Hollywood protects men, although that seems contra to facts and reality, but I'm not sure why facts and reality have ever stopped us yet, so, you know. In order to find Miss Heard liable for defamation by implication, a court must make numerous leaps of logic that are not justified by the actual words of the op-ed or reasonable implications thereof. Requiring victims to defend such lawsuits without proper First Amendment protection will cause the speakers either not to speak, and then there's a footnote. While the trial of this case was incredibly invasive into Miss Heard's privacy, what the hell? With such irrelevant matters such as testimony about the alleged incident in the Seattle airport in her past. For most victims of abuse, it's the invasiveness of pretrial discovery, including depositions, that's the most harmful. Yes, heaven forbid that we put the people who are making claims against men under oath and make them ask questions. The depositions are really, really harmful. The depositions are really, really harmful to victims. Super, super harmful. Because you see, the thing is about depositions, and I don't know if you guys know this, the thing about depositions is you have to swear to tell the truth, and then the mean lawyer gets to ask you questions and probe and stuff, and that doesn't seem true because of here's some evidence that seems to counter what you're saying, or really, or who did you talk to about that, or what did they say, or so forth and so on, as we challenge the veracity of what you're saying, the veracity, so that we can reach a good verdict. Veracity, verdict. I wonder if they have anything to do with each other. Requiring victims to defend lawsuits without proper First Amendment protection will cause speakers either choose to not to speak or to incur significant costs, usually against litigants who have far superior assets. Do they? Do they have far superior assets, really? In most cases? How do you know that? How did you reach that conclusion? There's no citation for that, incidentally. So we're just making that up out of nowhere. The publication at issue, the Washington Post op-ed. I like how they write op/ed. Just an interesting stylistic choice, but okay. On December the 18th of 2018, the Washington Post published, first online and then in print, an editorial written by appellant Amber Heard, well, at least it was signed by her, with the assistance of the ACLU. With assistance of, we mean penned by them, but that's a kind of assistance, I suppose. Just doing it for you is a kind of assistance. Miss Heard had been invited to become an ambassador by the ACLU. I wonder what might have been at the basis of that decision. And to work with the ACLU on an op-ed to bring attention to gender justice issues. But aren't men a gender too? But apparently not. No, apparently not so much. No. Apparently not, no. As well as to galvanize support for changes in the treatment of women who have come forward to speak out against abuse. Are women mistreated who come forward? That doesn't seem to be true, based on what I know, except if mistreatment means asking them a question and challenging the veracity of what they're saying. So if challenging veracity so that we might reach a correct verdict is bad treatment, then I guess, yeah. Heard advocated that readers help elect politicians who would assist in fighting abuse and pave the way for better investigations by providing proper follow-through of complaints and assurance of no retaliation. Well, what are we saying retaliation is exactly? What is retaliation? In the op-ed, Miss Heard explained that because she'd spoken out about domestic abuse, she'd been ostracized and lost employment as an actress. That's not really what I understand the facts to be. In the immediate aftermath of the op-ed, I think her career did pretty well. Maybe when people found out she was a lying liar, so maybe she's lost jobs now because she's a lying liar domestic abuser. And we know what happens to men domestic abusers, so shouldn't that happen to women domestic abusers? I guess not. As the Washington Post later wrote, the op-ed urges readers to support women who come forward with allegations of abuse by taking them seriously and electing politicians who will fight for changes to laws and rules and social norms. Well, taking them seriously means probing, right? Isn't that how you take something seriously? I'm taking this brief seriously. I am reading it. As a Virginia admitted lawyer, I am admitted to the bar of Virginia. I am licensed in Virginia. And I've been a lawyer for 15 years. And I'm taking it seriously. I took the entire trial seriously. You guys know I did. I was there every day, mostly on Legal Bites channel, doing some wrap-up coverage on my own channel. Popped in, I think, once on Joe's channel, popped in once or twice on Nick Ricada's channel. But I was watching it every single day. I was considering the evidence every single day. And I went into it, and for the first 3 weeks, I said, Johnny Depp's going to lose. Because, I had absolutely no way to predict that Amber Heard was going to get on the stand and tell a story that was so incredibly disparate from the evidence. I guess I could have predicted that if I had done more research in advance of the trial. But it's often my strategy, although not always, but it's often my strategy to go into the trial blind. Because I want to make decisions based on what the jury hears. Right? The jury is supposed to be blind. They're not supposed to have any opinion going in one way or another. To the degree to which that's true or another, we could debate. But that's the ideal. And so it's like, okay, I want to come in with the ideal. So very often I come into these trials deliberately ignorant of what's happening in the public zeitgeist, not for least reasons, because as we know, the media can sometimes be crap. And so what the public zeitgeist says may have nothing to do with what's actually happening in trial. Like, there's a contention for you. Maybe what the media has been suggesting about a trial is not actually what the trial is. What an amazing idea. So very often, although not always, I go into these things blind. I went into Johnny Depp mostly blind. And so I had no way to predict, because who could see such a thing coming from a blind posture that Amber Heard would go on the stand and say things that were just not possible based on the evidence. Oh, I was thrown on a table. I was choked. I was penetrated with a liquor bottle. I was beaten. I was on a pool table, and he was on top of me, flailing at me. The next day, I was on the Jimmy Dore Store show with professional cameras, and there was no signs of swelling because the makeup was just that good. Also, we heard from the makeup girl, and we saw photos of Amber Heard from before makeup. And the makeup girl saying, is this what she looked like before the makeup? Yep. Were those photos of a savage beating? Nope. So, the reason my opinion changed is because I'm like, oh, this is completely irreconcilable. And so the case for Amber Heard just went into a tank and it never recovered. But I'm not sure how much more seriously I can take this. I'm not sure how much more seriously I can take it than by viewing the entire trial, by reading these amici briefs, by reading Johnny Depp's brief, and thinking through it and trying to assess it and trying to probe critically. I suppose what they mean by taking seriously is believe it implicitly. So their view of what taking it seriously and my view of what taking it seriously are seem to be very, very disconnected. Chameleon asks, how come the case went there? Because the Washington Post, who printed the article, is based in Virginia. So that was the site of the publication. That's why. Washington Post is based in Virginia. So that was a valid, because originally we sued the Washington Post too, I think. And either way, that's where the publication happened. So it's a valid place to choose. There might be other valid places to choose, but Virginia is a valid place to choose, right? And if you have more than one, it's up to the plaintiff to choose the venue. So more than one place could have been a valid venue. Virginia was a valid venue. Virginia has decent anti-SLAPP laws, although not the best, but, that's why. Anyways, the op-ed never mentioned Heard's former spouse by name or by reference, such as former spouse. Yes, but we're not that dumb. We're not that dumb. The question is, what does the ordinary man understand when reading the article? What does the ordinary, normal, common man of ordinary, normal prudence, what do they understand it to be talking about? So we never mentioned them by name or by former spouse, but are we talking about Johnny Depp? If the reasonable man can say yes, it's a valid point for the jury to consider whether it is yes. The reasonable man can understand potentially different things, right? Because there are potentially a variety of views for the reasonable man. Although Amber Heard is a truth teller, is a hard pill for me to swallow as the view of a reasonable man. But at least in principle, a reasonable man can potentially believe lots of different things. And then which of those things is the truth is up for the jury to determine. The reasonable man could believe this, or could believe this, or could believe this, or could believe this, or could believe this. Which of these things isn't, jury? That's what we have juries for, as finders of fact. To determine the facts. That's why we have juries. Great. Instead, other than the contested passages, the op-ed merely explained that she'd been exposed to abuse at a young age. And like many women, she had been harassed and sexually assaulted by the time she was of college age. Not for nothing, but I wonder when she says sexual assault what she means. Because at this point, I'm not sure what she means by sexual assault. Do you know what she means by sexual assault? I'm not sure I know what she means. Yeah. The introduction of the op-ed listed Miss Heard as an actress and ambassador on women's rights at the American Civil Liberties Union. Yeah. There's a little footnote here. Miss Heard did not meet Mr. Depp till long after she was college age, so this reference can't be to him. Well, if that reference isn't to him, I'm sure there's no references to him anywhere in the article. That's how that works. Because that one doesn't reference him, it's therefore true that none of them reference him, because that's logically true. Oh, wait, no. No, it's not. The op-ed itself contains two sentences written by Heard that Depp claimed were defamatory by implication. Then 2 years ago, I became a public figure. First of all, there were 3 sentences, not 2, by the way. So I'm not sure why you're getting this wrong. There were 3 sentences. It was in the jury verdict. I'm not sure why you're getting this wrong, but okay. Then 2 years ago, I became a public figure representing domestic abuse, also the headline itself. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. Yeah, what happened 2 years ago? I had the rare advantage of seeing in real time how institutions protect men accused of abuse. Which men might she be referring to? And then, as noted by Randy, she did in fact testify that it was in fact about him, which means it's pretty reasonable for the reasonable man to think it was about him, right? Who was it about? Amber Heard. I mean, those are distinct questions. So we'll give the devil its due, right? Because again, I was making this point yesterday. We have 2 things that we have to consider: what's true in sort of reality, and what's true in her head, right? So she's saying, okay, this article was about Johnny Depp is only informative, not determinative to the question. The question isn't what she meant by it. The question is, what did the ordinary man understand it to mean? The question is, what did the reader or listener understand it to mean? What did they understand to be referring to? So it is possible, of course, that Amber Heard might have intended to be talking about someone, but the listener not understand that. And I think we can think of examples, if we put our mind to it, where someone is so oblique about what they're talking about, we don't know what they're talking about, even if they have someone in mind. But they're so oblique, we can't follow the thread through. So, but the fact that she had that subjective understanding herself makes it more reasonable. The reasonable man, who is our vantage point of consideration, understood it that way. Like the reasonable man thinking, oh, it's about Johnny Depp. Her thinking, her subjective state of, I intended it to be about Johnny Depp, makes it more likely the reasonable man's conclusion is correct. But there is a slight distinction between the two. And as long as I'm trying to provide a legal education, I thought, it's worthy of mention, right? So what the reasonable man understands the article to be is the consideration. Amber Heard's subjective intent is at best informative to that question. But I hope you enjoyed that minor point of legal knowledge. Neither mentions Mr. Depp nor specifies any type of abuse: mental, psychological, verbal, physical, emotional, or sexual. That's not how I remember the headline being. I guess it's true that those particular statements didn't say it, which I guess is the way you characterize it the way you did. The statements on their face do not assert that Heard was subject to any abuse by Depp. That would be the difference between defamation and defamation by implication. Although he pled both, and, you could argue it too. The rest of the op-ed addressed repercussions experienced by women who speak up regarding abuse. The op-ed took a broad view, referring to the Me Too movement and the history of Hollywood of facilitating abuse and punishing women who objected to it. It opined that we're in a transformative political movement in which women's rage and determination to end sexual violence are turning into a political force. Ms. Heard's general description of her own experience was limited to a few introductory sentences at the very beginning of the op-ed that were not associated with Mr. Depp. Well, explicitly, maybe. By implication, go ask the reasonable man. Right? Go ask the reasonable man. What does it mean? Who is the reasonable man? The reasonable man is the normal, ordinary, common person of ordinary, normal, common prudence. He's the man on the bus. He's not particularly rich. He's not particularly poor. He's not exceptionally well educated either. He can get on a bus. He knows timetables and how to keep time and how to pay for change on a bus. He's the reasonable man. Who is the reasonable man in practical reality? The jury. That's exactly who the reasonable man is in reality. The jury. That's why we get juries. And the 12 of them, or 7 of them in this case, as it were, 7 of them in this particular case, get together and they say to themselves, what would the reasonable man think? And the jury thinks to themselves, what would I think? And then if all 7 of them agree, then, hey, that must be what the reasonable man would think, because we have 7 reasonable jurors. And 7 reasonable jurors have come to this opinion. That must be a valid vantage point of the reasonable person. Thanks, jury, for clearing that up. That's what the reasonable man thinks. Yeah. A different jury could have come to a different conclusion. But, this is how we do it. We ask a jury what they think, and that's the answer. All right, let's talk about other negative publications about Mr. Depp, because that matters for some reason. Because whether or not Mr. Depp was negatively treated or even defamed in other publications has a lot to do with whether or not he was defamed in this particular article. You see, the thing is, like, if Mr. Depp was treated negatively and defamed in other things, that means it's less likely that he was defamed in this article. No. I don't know. No. Um, if everyone is speeding down a road, officer, officer, I know you pulled me over for speeding, but everyone else on the road was speeding. Therefore, it is less likely that I was speeding. Eh, eh. Yeah. Brenda says, love your definition of a reasonable man, a man who can successfully rise to the bus. Yeah, that's not my definition. That's the law's. Different countries use different examples, but it's the same principle. They use more local examples. I can't tell you what they are off the top of my head, but like in England, it's the man who rides, I think it's like a particular subway. In Australia, it's like the man who rides the whatever tram. Like basically, this isn't my thought about the man who rides the bus. That is literally legally what it is in the United States. Other countries use slightly different examples that are more locally relevant. But that is literally the legal definition of the reasonable man in the United States. The man who rides the bus. That's who it is. So, yeah, there you go. He's not particularly rich. He's not particularly poor. He's not exceptionally well educated, but he's not an idiot. You know, he can tell time and he can read a bus schedule and he knows how to get to the bus stop on time to get to the bus, and he knows how to get onto the bus, and he knows how to make change for the bus and receive change, and he knows how to get on the bus, and he knows where to get off the bus. Right? This is literally legally the standard for what the reasonable man is. That is the guy, is the man who rides the bus. Legally. Congratulations. It's great. All right. Anyways. While the Washington Post op-ed did not mention Johnny Depp, numerous other publications reported in great detail about how his drug and alcohol use, abuse of Miss Heard and others, and failure to honor obligations to show up on sets in a timely manner results in financial loss to studios. I'm not sure how any of that has anything to do with the price of tea in China. CG says it's a pretty low bar. Yeah, it is a pretty low bar. It's a pretty low bar because, well, for better or worse, we are a constitutional republic, and the man who rides the bus is the voter. Right? It is a pretty low bar because, well, he's he's the everyman. He's the everyman. This is as sophisticated as we need to get. But that's the relevant legal standard, so okay. These articles caused Mr. Depp's poor reputation among various studios and others in the movie industry. Years before Heard op-ed was published. Who cares? This is going to like damages. And whether or not he's late on set has piss all to do with whether or not he's a sexual abuser. Miss Heard was prohibiting from entering these into evidence based on erroneous hearsay. Also because they're legally irrelevant. Also because they are hearsay. Had the articles been admitted to evidence, the jury would have learned about other reporting that would have affected Mr. Depp's reputation. When it comes to him being a wife beater, there were reliable predictions that Depp would not be in any more Pirates of the Caribbean movie almost 2 months before the op-ed was published. Yeah. Mr. Depp's business managers filed pleadings in a lawsuit against him, asserting they knew Depp had engaged in violence against Miss Heard. Depp was described as extremely volatile and had sometimes gone physical with Miss Heard. Apparently, this is the headbutting. We might have headbutted once. Guys, I'm sorry. Look, I'm just, no. If your claim is my husband headbutted me once, unless it is the most violent and intentional headbutt of all time, I'm sorry. No, that is not abuse. No. No. People bump heads sometimes. Everybody bumps heads. Sometimes gotta hold on. Depp drank heavily and was constantly late to the set. Depp went on 72-hour drug binges, was only intermittently lucid, spent $30,000 a month on wine. Well, some of that seems to have been for Amber, incidentally. She only drinks that good shit. It's like $500 a bottle. Many of Depp's movies were bombing at the box office. That has piss all to do with whether or not he is a domestic abuser. Oh my God, some of his movies weren't as successful as other movies. Also, that would be just within the knowledge of a normal, ordinary person. So, Depp physically assaulted the location manager of his film City of Lies and was sued by the manager. Prior bad acts, anybody? Depp joked about assassinating President Donald Trump. I wonder how many people who signed on to this brief joked about assassinating President Donald Trump, just out of raw curiosity. You know, people in glass houses and all. Thank you, Merms, for the 5 gift memberships. Thank you, Merms, for the 5 gift memberships. But I gotta wonder, how many people who signed on to this brief joked about assassinating President Donald Trump? I'm guessing the answer is some. And was rebuked by the White House, requiring an apology from Depp. Depp was going broke and selling many of his assets because of his grossly expensive spending related to drug, alcohol, and extreme eccentricities. How does this have anything to do with whether or not he beat his wife? Does anyone know? Thank you, Sandra, for the gift memberships. That's very, very kind. None of these articles were sought to be introduced for the truth of the matter. Really? They weren't? But rather demonstrate other publications contain more damaging allegations about Depp and were more likely the basis of any difficulties experienced by him. I don't know. I think he shows up to set drunk and takes drugs is not quite in the same category of thing as he beats his wife. Yet the trial court did not permit the jurors to review these articles because they're bullshit. All the allegations Mr. Depp now contends were implicit within the op-ed were not only public knowledge, but it's been circulated ad nauseum long prior to publication. Well, if it truly had been circulated ad nauseum, the jury was already aware of it. By the time Miss Heard published her op-ed, Depp's was nearly defamation or libel proof. Wow. Defamation or libel proof. Wow. Because some of his movies hadn't been successful, because sometimes he showed up late on set, because he might have spent $30,000 a month on wine, because he might have used drugs sometimes. He's defamation. He cannot be defamed. He is beyond defamation. His character and reputation are such absolute complete garbage. It is literally not possible to defame him anymore. Because of these things. Because of these things, some of his movies weren't successful. He showed up late to set sometimes. People were talking about him not being in another Pirates of the Caribbean movie. He spent $30,000 a month on wine. Because of these things, his reputation was already in such complete tatters, it was not possible to defame him anymore. Wow. Wow. That is some big ass balls to make that argument. He's defamation or libel proof. Harvey Weinstein is defamation proof. I'm not so sure about Johnny Depp. Shit. What a joke. Depp unsuccessfully British lawsuit against the Sun. Well, I'm not sure how to break this to the people who wrote this, because maybe they don't know. Maybe they're not keeping up on their news. But British law doesn't have quite the same command in Virginia that it once did. There was definitely a period of time when British courts had a stronger influence on the cases of Virginia. You might have missed the memo, though. There was this slight minor confrontation, not barely worth mentioning, and now the British courts have less authority over Virginia. Just a minor event. Might have missed that one in the news. Yeah, okay. One of the most damning articles published before the Herd wrote the op-ed was written by Dan Wooten in The Sun, a British newspaper, published in 2018. Mr. Wooten expressly stated that overwhelming evidence was filed in a California proceeding against Depp by Herd to show Johnny Depp engaged in domestic violence against his wife Amber Heard. Wooten explicitly encouraged J.K. Rowling, the author of the Harry Potter book series, and Warner Brothers, the studio making Harry Potter films, to fire Depp from his role for playing one of the key characters in Fantastic Beasts. In response to this article, Depp, through counsel, filed lawsuits before the High Court of England and Wales against Wooten and publishers of The Sun, claiming irreparable harm from the Sun article. Yeah, the lawsuit was against the Sun, not against Amber Heard. So there's that. The defendants filed a re-amended defense that relied upon truth defense, specifically saying the claimant beat his wife Amber Heard, causing her to suffer significant injury, on occasion leading her to fend for her life. Yeah, that seems to be some bullshit. And I know Black Belt Barrister was trying to get a petition going to get the case reopened in Britain. And I wish him all the luck, because this lawsuit looks like some bullshit. The standard for defamation in the UK is a lot easier. It's a lot easier to sue for defamation in the UK than it is in the US. So the fact that Johnny Depp lost in the UK and won in the US is backwards from what you would expect. It's harder for him to win in the US, but he won where it was harder. And he lost where it was easier. Thank you, by the way, for all the gift memberships, Merms. I appreciate that, by the way. Thank you for all the people who donate gift memberships to the Uncivilians. I really do appreciate it. You can become an Uncivilian too, by the way, by hitting that join button. And if you don't have a join button, Streamlabs tells you the link from time to time. For example, it tells you the link just now. So you can click on that link and you become an Uncivilian. For 99 cents a month, it's literally the least YouTube will let me charge you, you can become an Uncivilian. It's true. For 99 cents a month, you get cool little scales by your name. And also, you get access to some cool emojis. And I'm experimenting with, and almost certainly will roll it out as a formal member benefit in the near future, for the Tier 2 membership, which I believe is $5.99 if I remember correctly, previews of stories that I record. So edited stories will probably become a membership benefit for the $5.99 level if you want to join at that level. Trying to give people who donate to the channel some, benefit for doing so. So for 99 cents, you get the cool little scales of justice and you get the cool little emojis. And for $5.99, you get access to stories before other people see them. Really, really cool. So make sure to click that link or click your join button today. Let's go back to the stream. All I want for Christmas is your 99 cents. Lol. It's less than a cup of coffee these days. You know what I mean? And like coffee is even expensive. Even black coffee is expensive. All right. The Sun argued that the claimant and Miss Heard began living together in or about 2012 and married on the 3rd of February 2015. They separated on or about 22nd of May 2016. Throughout their relationship, the claimant was controlling and verbally and physically abusive towards Miss Heard, particularly when he was under the influence of alcohol and drugs. After 16 days of hearing in the case, on November the 2nd of 2020, Mr. Justice Nichol, sitting in the British High Court of Justice, Queen's Bench, issued his judgment. 129-page, 585-paragraph decision that's obviously crap, which found the statements in the Sun that Depp beat his wife, Amber, causing her significant injury and on occasion leading her to feel for her life was substantially true. Yeah, I'm not sure about that one. Thank you, Becky, for the super chats. Appreciate everyone who super chats as well. Your super chats go up on the screen, and I want to make sure that you get acknowledged. So that's, yeah, you can be that's right. Lisa has it right. You can be a member for 6 months for what a price of a cup of coffee costs. Yeah, it's yeah. It is literally the least YouTube will let me charge you. I tried to make it accessible to everybody. In the judgment, the High Court noted that the burden of proof to the civil standard of proof, namely balance of probabilities, was on the defendant to establish the statements were true. The High Court found that the great majority of the alleged assaults by Miss Heard by Mr. Depp have been proven to the civil standard. Yeah, the court might be full of shit. As a result, the High Court dismissed the claims brought by Depp against defendants. On March 25th of 2021, the Court of Appeals refused Mr. Depp's application for permission to appeal because apparently in the UK you need to ask nicely, can I appeal? Which seems like it gives the trial court a lot of power, or the Court of Appeals a lot of power. You have to ask for permission to appeal. Which seems, okay. Thank you, Merms, for the £5 for the coffee. I appreciate it. More than 2 years after this article, Mr. Depp resigned from this role after losing his lawsuit in November 2020. There is substantial adverse press about Mr. Depp at the time of the filing by Depp, during the hearings and trial, and after the judgment. Yeah. The Depp v. Heard trial. To say the Depp v. Heard trial in Fairfax County Circuit Court and its surroundings was a circuit is a gross understatement. I know. The public was able to view the thing. What kind of coffee? Iced coffee. My favorite thing to get is usually double espresso on ice with heavy cream. And failing that, black coffee on ice with heavy cream will be fine. But yeah, that's how I like my coffee. And a little sweetener, like a stevia or something is not unwelcome. But yeah. But the problem here is that the Depp v. Heard thing was a circus because the proletariat was able to view the thing. Instead of only the bourgeoisie, the proletariat was able to view the thing and reach their own opinion. The common masses, swaddled in their target clothing, were able to view the trial and hang with us, the aristocrats. Yeah. The public was able to view it and have an opinion on it. As the unofficial video record has shown, the outside entrance drop-off gauntlet through which both parties entered the courthouse and through which Depp was championed and Heard was vilified, not for least reasons because of how Heard treated the staff, incidentally, and the conduct of the courtroom audience and some of the participants, created an atmosphere more appropriate for a trivialized wrestling match than a court impacting people's lives. Wow. Wow. Social media lambasted Miss Heard and viciously attacked anyone who expressed opposition to Depp because it doesn't make any sense. I don't get it. I don't understand how you can oppose Depp at this point. I want to be an open and fair-minded guy. I really, really do. I try really hard, but I don't know how you get there without just saying that, only women should be believed. I don't know how you get there without misandry. I don't know how you can think that Depp wasn't a victim. I don't know how you can think that Amber Heard wasn't clearly lying when she talked about this absolutely violent abuse with a man with rings on it, nonetheless. And then the next day she's on camera, on set, and she looks fine. And she might have had a little bruising on her arm one time. It's like, this doesn't gel. I don't understand. I really want to understand it on some level because I want to check my own reasoning. Because I could be wrong. I can always be wrong. So I want to check my own reasoning. And I just don't understand how. I don't understand how these people think. It seems odd, so odd to me. I don't get it. Oh my God, they actually cite Bot Sentinel. Wow. Targeted trolling and trend manipulation. How organized attacks on Amber Heard and other women thrive on Twitter. Report, Bot Sentinel. Wow. Yeah, I'm having microphone problems. G4 outdoors. I'm having microphone problems. I'm having laptop problems. So I'm stuck with this bad audio. But what I'll do after this stream is I'm going to re-upload both yesterday's stream and today's stream with some sound management, and hopefully it will become better. I apologize for it. I have a microphone, but for some reason, my dad's laptop that I'm borrowing won't accept that microphone as input, and my own laptop won't power on. So we're making do with the best we've got. It totally sucks. Let's press on. The lack of decorum was further exacerbated by social media postings, which belittled Heard and heralded Depp's attorneys. For Depp were shown making inappropriate gestures and harassing witnesses when they're on the stand. While being praised by the mob. The mob has opinions. The mob has informed opinions. All these elements, which are predictably result of defamation suits and properly filed and involving public figures, show speakers who should be protected by the First Amendment. It's difficult to overstate the amount of historical interest the case attracted and its long-term impact. Broadcast of YouTube segments amassed a total of 83.9 million hours, watched with a 3.5 million peak viewers during the announcement of the verdict. Yeah, people had opinions and they wanted to see, so they could view them themselves. The opening argument. Thank you, by the way, for all the super chats coming in. By the way, this is a PR leak. Well, this is an amicus brief, unfortunately. And Glow T, thank you for the super chat for saying thank you for all you do to inform us. That's very, very kind. I appreciate it. The opening argument of Depp's counsel, the evidence presented by Depp, and Depp's closing arguments would lead a reasonable juror to believe that the defamation being sued on by Depp was not the op-ed itself, but rather the allegations of abuse by Heard in 2016. Yeah, because the op-ed itself said 2 years ago. So it brought all that into the fold of the article. So it became relevant to the understanding of the article. As Benjamin Chu, Depp's attorney, stated in his opening, the evidence will show that Heard's false allegations in 2016 had significant impact on Depp's family and his ability to work. Depp's counsel later argued that what's at stake in this trial is a man's life, the life he lost when he was accused of a heinous crime. Only later did Mr. Depp's counsel correctly argue this case is about what Miss Heard said in her op-ed, but then went on to distort what Miss Heard said, even by implication. Like attorneys kind of do. They make arguments. Now, Depp's counsel argued that Miss Heard painted a picture of herself as a heroic, innocent survivor of abuse by Depp, a beaten woman who finally stood up to her tormentor. Yeah. The evidence will show Miss Heard portrayed Mr. Depp as representative of abusers everywhere, the agent of her suffering, the villain in her heroic journey. I mean, yeah, those are characterizations that are certainly fair game for an attorney, and I would argue more than that are a fair characterization. So they're both fair game characterizations, and more to the point, accurate characterizations. Uh-huh. My brain hurts. Evidence in this case was presented over 23 trial days. I know, I watched them. Interestingly, Depp did not introduce into evidence a copy of the op-ed that was the basis of the lawsuit until April the 20th, 2022, the seventh day of evidence. And his counsel mentioned it only in passing during their opening statement. During the trial, Mr. Depp asserted that when Miss Heard made abuse accusations against him in May 2016, these accusations had immediate impact on his career, saying when she made those accusations, he lost nothing less than everything. That's what Depp said. His counsel repeatedly argued that Depp's claims were focused on the allegations that Miss Heard made in 2016. Yes, because the op-ed itself said 2 years ago, and 2 years ago was 2016 relative to the article. Mr. Depp's closing argument began by asserting, do we not understand how closing arguments work? That seems to be what we're going for. We're not quite sure how closing arguments work, I guess, at this point. On May the 27th, 2016, Miss Heard walked into a courthouse in Los Angeles, California, to get a no-notice ex-parte restraining order against Depp, and in doing so, ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp. Today, on May the 27th, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Miss Heard has said he is, and to hold Miss Heard accountable for his lies. Her lies. Yeah, that's what we call rhetoric, people. That's how rhetoric works and argument works. That's literally how argument and rhetoric works. What you do, you see, is you make a persuasive argument. You want You want people to hear the argument and be persuaded by it in a rhetorical style that also tells a story with a narrative arc, such the story drives the jury to one inevitable conclusion. Yeah. 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 Okay. Give me just a second. I'll get there. Okay. Thus, Mr. Depp and his counsel asked the jury to hold Miss Heard accountable for the filing of the restraining order in 2016, not for the op-ed. Post-verdict information. Despite the fact that the identities of the jurors had been sealed, after the trial ended, one juror chose to speak out in response to various comments made by Heard and counsel. The jury said that they, Depp and Heard, were both abusive to each other, but to rise to the level of what she's claiming, there was not enough evidence. What she is claiming is literally a question for the jury in this context. Because what the op-ed means is a question of fact for the jury. So what her allegation is in the op-ed is one of the questions the jury has to answer. What was she alleging? Was it about Depp? If so, what was she alleging about Depp? Now, what she wants to do is say, well, I was talking about abuse, and everything can be abuse. But the question is, what did the reasonable, ordinary, common, normal person understand the article to be talking about? Because if you tell me that a husband abused his wife, I think physical violence. I'd like to think I'm a reasonable man. I really would. But if you tell me a husband abused his wife, I think to myself, physical abuse. I don't think to myself, psychological, or maybe one time they headbutted. That is not what goes through this listener's mind as the images that the term abuse portrays. So in a court of law, in a domestic violence context, or in a divorce context, or in a battery context, where we're talking about precise definitions, then maybe. But me, just reading an article that says abuse, I'm not thinking whatever this bullshit is. So this juror's statement makes perfect logical sense. They abused each other, but not to the degree that she was alleging. If that's how they understood the article, that's literally the correct conclusion. The juror further stated that Heard's team failed to prove Depp's abuse was physical, thereby demonstrating the juror's misunderstanding of the burden of proof and the full term of the scope abuse. See, this is where they make a mistake. This is where they make a mistake, among many. This is definitely one of the points where they make a legal mistake. The term abuse, what it means, is what is understood by the reader. That's what it means. Abuse has been defined by various courts in various contexts for other purposes. So if we were talking about a battery claim, if we were talking about an assault claim, if we were talking about a domestic violence claim, if we were talking about a divorce claim, what constitutes abuse in those contexts would be a different thing. Because abuse in those contexts is defined by law, defined by statute most of the time. Thank you very much for the gift memberships, by the way. Sandra, that's very, very kind of you. 20 gift memberships. Thank you very, very much. But what the term abuse means in this op-ed is a question for the jury. So I don't think the jury misunderstood. I think abuse can refer to many types of actions. Maybe, but the question is, what did the jury understand that was being communicated? Abuse can take many forms, including self-abuse, which at this time takes the form of me reading this brief. More than half a century ago, the Virginia Supreme Court recognized the power of abusive language during a relationship. Angry words, coarse and abusive language, humiliating insults, and annoyances in all forms that malice can suggest may as effectually endanger life or health as personal violence and afford grounds of relief to the injured spouse. In a divorce context, in a domestic violence context, possible, where those terms have specific definitions. The question is, when the ordinary, common, normal person of ordinary, normal prudence read the op-ed, what did they think it meant? What did the man on the bus think it meant? Do you think the man on the bus was having this really high, sophisticated, given what I've told you the definition of the man on the bus is, do you think the man on the bus was having this incredibly sophisticated discussion of like, well, abuse can mean many different things. Maybe it just means purely some mean words were said once. Or do you think the man on the bus was more likely saying to themselves, they mean physical abuse? Also, I'm a fairly well-educated man, and I would be thinking physical abuse. So, yeah. In an article, I'd be thinking that. Virginia courts, recognizing the serious nature of psychological abuse, have granted protective orders. Protective orders against abusive family members, even without the threat of violence. Yes, if we were talking about a protective order, we might think about abuse differently. But we're not in the context of a protective order. We're in the context of defamation. You guys seem to forget that, brief writers. During the trial testimony, Mr. Depp acknowledged the various forms that abuse may take, including emotional abuse, verbal abuse, physical abuse, and psychological abuse. Yes, he did. But the question is, what did the article convey? Abuse can take these forms, but which form or forms of abuse was the article conveying to the normal, ordinary, common, normal, prudent person of ordinary, common prudence, the man on the bus? What did it convey to him or her? The normal man who's not particularly educated, but he's not a dullard, who's not particularly rich, although he's not completely impoverished. The man who can read a timetable, get to the bus stop, board the bus, make change, know when to get off of a stop, how to get back onto the bus, how to reverse the process to get home. What do they think that thing means? Intimate partner violence is a significant problem in Virginia and the U.S. Understanding of abuse, especially domestic or intimate partner abuse, has increased in recent years. There are at least several categories of intimate partner abuse, each of which causes lasting harm and can escalate. According to the Centers for Disease Control, the National Intimate Partner and Sexual Violence Survey, intimate partner violence includes physical violence, sexual violence, stalking, psychological aggression, including coercive tactics, and control of reproductive or sexual health by a current or former partner. The CDC report supports defining emotional, coercive, verbal, and mental abuse, among others. Yeah, if you define abuse wide enough, though, it ceases to have any meaning. Or it means everything, which is kind of the same thing. Within intimate partner abuse is psychological aggression, which includes expressive aggression, such as name calling, insulting, or humiliating an intimate partner, and coercive control, which includes behaviors that are intended to monitor and control or threaten an intimate partner. Similarly, as the CDC has explained, sexual violence includes non contact abuse. Sexual violence includes non contact? Okay. Sexual violence includes non contact abuse, such as non contact, unwanted sexual experience of verbally sexually harassing the victim, making a victim look at or participate in sexual photos or movies, and sexual coercion, threatening to spread rumors and sexual pressure due to someone using their influence or authority. So sexual violence also includes non-physical. These definitions are becoming wider and wider with every moment, man. The CDC report determined that abuse has multiple types and recovery from abuse is not only a matter of healing bruises, which is convenient, I suppose, since Amber Heard didn't have any bruises, despite the vicious ring beating that we discussed earlier with the bottle. As the report found, while psychological aggression by intimate partner was experienced by 47.1% of women, well, dude, if you define it this widely, I guess, yeah, I'm surprised it's not more. Only 47% of women. Why is it not all the women? You know, when you define it this widely, so that it means everything, and you dilute it to such a degree it doesn't mean anything, 47% of women fall within this incredibly broad category. I wonder what percentage of men fall within this incredibly broad category, just out of raw curiosity. I'm surprised it's not everybody at this point. Physical violence by an intimate partner was experienced by almost a third of women. I wonder how we're defining physical violence at this point, too. Given the way we've expanded other definitions, right? Normally, I wouldn't ask that question. But since sexual violence apparently includes non-physical violence, including all these things, I wonder how broadly we've stretched out the definition of physical violence. What do we mean by physical violence is now a question I actually have to ask. What does that mean, to be physically violent? Normally, I wouldn't ask that question because I know what I think the answer is. But given the way that these people are expanding definitions beyond all know and hope, I think physical violence probably includes non-physical non-violence at this point. It's like interstate commerce. It means everything. Both these types of abuse were found to have profound effects on women. And then there's some citation to some numbers, which I don't have any confidence in. Combining sexual violence, physical violence, and/or stalking by an intimate partner and psychological aggression, along with just anything else we want to mean, I guess, there are almost 600,000 female victims in Virginia in 12 months and almost 25 million female victims in the country. The levels of intimate partner abuse over lifetimes is even higher. The majority of females, 73%, and over a third of males, 35%, lifetime intimate partner violence victims have experienced one or more intimate partner violence-related impacts. Again, with the definitions these wide, I'm not surprised. Why don't you just make it wider so it's 100% of women? Commonly reported IPV-related impacts for both women and men were fearful, being concerned for safety, and experienced symptoms of post-traumatic stress disorder. Well, if that's the definition, I might fall into that category. No joke. But I don't know. These categories are so wide. According to the CDC report, sexual violence, stalking, and intimate partner violence are important public health problems that have enormous and long-term physical and mental health impact on victims. The CDC report establishes that intimate partner abuse is a significant problem in Virginia and the United States. Well, given how wide we've defined it, no worries, no wonder. It means anything we want to mean. It's the all-encompassing, man. $10 from Senshi. Physical violence is interstate commerce, and bees are fish. Welcome to law. Yeah, that's a good one, Senshi. That's a good one. The CDC establishes that intimate partner abuse is a significant problem in Virginia and the United States. A recent medical journal study placed an economic value on the losses to American society because of intimate partner abuse. There's a citation to the Juvenile Code. That's nice. Concluding that losses to the U.S. economy and lost wages, impaired health, property damage, treatment costs, and lost productivity caused by intimate partner violence are more than $3.6 trillion over a victim's lifetime. Okay. What? In this research, even more adults reported other forms of intimate partner violence, including non-contact sexual violence. Non-contact sexual violence. That's an interesting concept. Non-contact violence is an interesting concept. The staggering number conveys the high cost of intimate partner violence to society. Nearly a quarter of female victims of intimate partner violence do not report the violence because they fear reprisal. I wonder how you know that. Perhaps you'll tell me how. An important 10-year Department of Justice study reveals that nearly 1/4 of women abused by an intimate partner do not report their abuse because they're afraid of retaliation. In Virginia and the United States, many abused women are too fearful to report abuse. I wonder what it is for men. Not reporting the abuse makes it more likely the abuse will continue and escalate because it will remain hidden in the shadows. The shadows. The abuser can continue to abuse because there's not been any adverse consequences. Over a 10-year period, almost half of non-fatal domestic violence victims were not reported to police. Over half? How do you know that? What are you citing? Apparently, the Department of Justice somehow came up with this. Half of the non-fatal domestic violence were not reported to police. Not sure how the DOJ came to that conclusion, but okay. The light of disclosure reduces abuse. There's a large amount of intimate partner abuse hidden by the shadow of non-disclosure, and much of that is based on fear of retaliation. If society wants to reduce intimate partner abuse, a key tool is encouraging and supporting reports of abuse. This verdict means that juries may ignore abuse unless it's extremely physical violence witnessed by third parties. Well, when you're claiming extreme physicality, a little bit. In several cases, even admission by an abuser has been insufficient for finding of abuse. Yes, because again, it depends on how the abuse is understood. So admitting to abuse, well, admitting to acts or admitting to things, is that abuse? Well, it depends on how we're defining abuse, which is part of the jury's role. So yeah, they may admit to it, but it's insufficient in findings of domestic defamation, because depending on how abuse is defined by the jury and depending on what the person admits to, the admission may not be abuse, even incidentally physicality. Because I think the opposite conclusion, the opposite conclusion is too absurd. The opposite conclusion would be that all physicality necessarily is abuse. And that seems absurd. That all physicality is necessarily abuse seems absurd. So if that's absurd, the opposite must be true. Only some physicality is abuse, which means that admitting to physicality may not be admitting to abuse. Because if some physicality is not abuse, because the alternative would be all physicality is abuse, and that seems absurd. then admitting to physical acts may not be sufficient to trigger the threshold of abuse. Right? Depending on, again, how the jury understands the term abuse within the defamation context. You know, if one partner slaps another once in the course of a 20-year marriage, is that abuse? Right? Because that would be the alternative. If all physicality is abuse, then that would necessarily mean that one partner who slapped another partner once in a 20-year marriage would be abuse, because all physicality is abuse. Right? If all, then that, because that would be some. And if that seems absurd to you, which it seems absurd to me, then it must be true that some physicality is not abuse, and so admitting to some physicality may not trigger the threshold of abuse. That's just logical reasoning. That's deductive logical reasoning. Informal logic. You know, if I wanted to, I could start breaking out the paper, and we could start breaking out the formal logic notations with the U and the upside down U and like the line, and we have P and we have Q and NP and NQ, and we could start doing this in formal logic notation if it would help. But that's just straight deductive reasoning. Yeah. All right, anyways. For an exercise at home, feel free to reduce that to formal logic. We get the three dots in a triangle. Good times. Okay. Okay. All right. So we read that part. I'm giving you homework. Sure. Yeah. Giving you homework. The verdict in the present case communicates that retaliation in the form of defamation action is a powerful weapon against women who report abuse. Well, if they're lying who lie, you know, yeah. The verdict punishes Miss Hurt for being brave enough to write about the abuse of women. Wow. The message is clear. No woman who voices her opinions about abuse is safe from retaliation. Jesus. This is your takeaway. If this is your takeaway, man, how bad is your thinking if this is your takeaway? No woman who voices her opinion about abuse is safe. Amber Heard or bust, man. The verdict will likely decrease the reporting of intimate partner abuse, with even less reporting of intimate partner abuse. A heinous problem for Virginia and the United States. Such abuse will worsen. Oh my God, won't someone think of the children? Because this case received such widespread attention, both in traditional and social media, holla, some women have already received the message that they should hide the intimate partner abuse in their life. Lol. Dr. Jessica Taylor, a psychologist, forensic psychology PhD, and author of 2 books on misogyny and abuse, says she's already been contacted by hundreds of survivors since the death verdict, wishing to retract public statements they've made in the press or are pulling out of court cases against their abusers. She says the verdict opens the floodgates for future defamation cases. I know. Instead of the 100 we had in 7 years, maybe we'll have 120 or even 200. For these women, this appeal is an opportunity to erase the message of this verdict, that reporters of abuse will be punished. How about reporters of lies? How about that? And also, Johnny Depp is a reporter of abuse, you idiots. He's being punished by your brief for coming forward. I have no problem with a woman coming forward with true claims. I think that we can talk about the nature of due process against men, but I have no problem with women coming forward with true claims. How we should go about adjudicating those claims with due process in mind, and also the fact that restraining orders can sometimes come with quite hefty practical penalties, including loss of gun rights, getting kicked out of your own home, losing your job, particularly if you have a security clearance, right? So they're not necessarily free. But I have no problem with women or men coming forward with true claims. I have a lot of problem with people coming forward with lies. Let's punish liars. Sounds like a good strategy to me. Reversal in this case will communicate that retaliation against women who report abuse is not acceptable in Virginia. Where retaliation includes literally asking questions and then saying, we don't believe you. That's retaliation. Just a friendly reminder from the sponsor of this video, me. If you have not already hit the join button, please do. For the 568 of you who are currently watching, the join button loves you and wants to feel your warm embrace. If you click the join button, it will become happy and elated, full of joy and content. Whereas right now, without that join button, it is full of sorrow and longing and wants to belong. You can help the join button today by clicking that join button, and for a mere 99 cents a month, you can help to support an Uncivil Law. And for $5.99 a month, you can get access to pre-release videos when I start making them again when I get back from the break. So, please do that. Please do those things. Summary of argument. The statements made by Ms. Heard were speech protected by the First Amendment to the U.S. and Virginia constitutions. The op-ed was an opinion piece with no direct connection or citation to Depp. It reflected Ms. Heard's opinion that society in general and Hollywood in particular have failed to support women who come forward advocating abuse. Ms. Heard, like any other American, is entitled to express opinion on issues of public concern. Mr. Depp has alleged statements by Heard using the term abuse and domestic abuse implied a defamatory statement about Depp. Based upon uncontroverted evidence at trial, those statements cannot be the basis for finding of actual malice by any reasonable jury because they were subjectively true from the perspective of Heard. I'm not even 100% sure about subjectively true. I'm not even 100% sure about subjectively true. Because the jury has the right to disbelieve Ms. Heard about her own state of mind. You can't even assume subjective truth. The jury is the finder of fact. That includes subjective truth as well as objective truth. So what did she believe in her own head? What did the reasonable man believe in his head? Are things for the jury to consider. So you can't even assume subjective truth. Not as a result of the jury, you can't. The jury could have listened to everything she said about her own state of mind and said, yeah, we don't believe that. We don't believe you subjectively think that. We do not think that's subjectively what you think. We do not think that's subjectively what you feel. We think you're lying. So you can't even assume subjective belief. That's a question of fact for the jury. What does the person actually think? What does the person actually feel? That's a question for the jury. Goes to their credibility as a witness. You dolts. So you can't even assume subjective truth, because what is subjectively true is for the jury to determine, as well as what's objectively true is for the jury to determine. That's why they're the finder of fact. Moreover, there was sufficient uncontroverted evidence at trial of actions that satisfied most reasonable definitions of abuse to be considered objectively true. Well, the question is, what did the jury understand the term abuse and domestic abuse to mean? If they understood it to mean physicality and more than headbutting, which is perfectly reasonable for the ordinary man to think, you just disagree with the jury. Mr. Depp alleged Ms. Heard defamed him based on implications contained in 3 statements from the op-ed. Thanks for saying 3 now. It was 2 earlier, but thanks for correcting yourself. Mr. Depp contends they included implicit innuendo, readily apparent to any reader. Yes, that would be the nature of the reasonable man. Do they contain innuendo? Ask the reasonable man. Who's the reasonable man? The man on the bus. Who is it? The jury. That's why we have juries. Ask them. Implying that Depp engaged in physical and sexual violence against Heard to restrict the known meaning of her choice of words on abuse to his viewpoint, not hers. If this defamation by implication verdict is allowed, it will have detrimental effects on the ability of commentators to facilitate true statements that could somehow be twisted by a public figure into allegations they had engaged in conduct not specified in their statement. Amici are concerned about this application of the doctrine of defamation by implication. The freedom to truthfully speak about abuse in general. Statements will be restricted if the op-ed's term abuse is held to imply actions that allegedly occurred and reported more than 2 years before the op-ed. Oh my God, do you know why they're talking about things that were reported 2 years before? Because Amber Heard wrote 2 years ago. She brought it to mind. The join button absolutely gives your consent to press it. The join button gives your consent to press it and gives your consent to hit the link and all those things. Make sure to do all those things. It totally thinks they're great. Please click the join button today. Yes, that'd be great. The term abuse was not defined in the jury instructions because it wouldn't make any sense. What it means and what it conveys is a question of fact. The judge shouldn't tell you because the judge telling you would make it an issue of law. It's not an issue of law. It's a question of fact. What does abuse mean? It's a question of fact. What does it mean? Ask the jury. As the court refused to give the jury guidance regarding the vague term that lacks a self-evident definition. That's the problem. You got it. That's the problem. You got it. You got it. You're there. You got it. You're right. It is a vague term that lacks specific definition. It can be understood to mean things to people because you didn't specify. What does it mean? What does it convey? Right? How do we determine which of the vague meanings was conveyed by the term abuse? How do we determine this? How do we determine which meaning was conveyed in the article? It's vague and undefined. How do we define it? What does it mean? Ask the jury. That's what they do. Do you understand how juries work? Do you understand how juries work? Hey, what did that person think in their head as they pulled the trigger of the gun? Were they afraid? Were they scared? Were they angry? Were they vengeful? Did they understand what they were doing? Were they not understanding what they were doing? What was the person thinking in their head when they pulled the trigger? Did they think that they had a gun in their hand or a banana? Did they think it was being pointed at people or aliens? Did they have fear in their heart or were they angry? How will we ever determine? How will we ever figure it out? Ask a jury! Is this guy telling the truth? Did this guy really see what he says he saw? Did this guy really hear what he heard? It was dark that night, but there was a moon, but it was cloudy, but there were parking lights, but some of the lights were out, and the guy didn't have his glasses, but he was close, but there were headlights. Did he see it? Did he hear it? Can he remember? How will we ever determine it? How will we ever know? How will we ever know what was going through this person's head? How will we ever understand what they were thinking in their own mind at the time? How will we ever solve this riddle? Yeah. Yeah. Okay. It is also alarming the verdict was allowed to stand given the utter lack of causation evidence, showing that this one op-ed was the source of Depp's financial troubles. Okay, guys, we have an op-ed. It's telling lies. It hurt his reputation. How much did it hurt his reputation? I don't know. How much did it hurt his reputation? How much did it hurt his reputation? I don't know. If only there were some sort of mechanism that we had. If only there was like some way for us to determine the amount of harm it caused. Here's an idea. Maybe we could get like a panel of people together and we could ask them, hey, did this cause harm? And if so, how much? And maybe the panel of people could tell us what the answer is. No, that's a strange concept. That would never work. No evidence was presented by Depp that any reader of the op-ed would have employed him, but chose not to had they read the article, much less a connection made between it. I don't know. However will we determine if people were hiring him or not based on the article? I don't know. How could we ever divine this mystery? If only we had someone to ask. It is next to impossible to say the alleged harm to Depp was due to some alleged innuendo in the op-ed, as opposed to dozens of other articles published in the 3 years prior. Hey, was it this article or was it these other articles? Did these other articles cause damage? How much damage did this article cause? How much did those articles cause? How much has Mr. Depp been hurt? How much of it is because of this? How much is it because of that? Did this article defame him? If so, did that article cause harm? Okay, how much harm did that cause? How much did this cause? Yeah. Yeah. The necessity of such a connection between any alleged defamation and real injury is crucial to protecting press and commentators. Lastly, amici are concerned that claimant has been permitted to litigate the exact same factual issues in two different fora and obtain two different and contradictory findings. Well, as I sort of alluded to before, this apparently is news, but the UK is a different country from Virginia now. They were the same country at one point. There was some minor things that happened in between. Virginia was the UK, and then not so much. So a different place, which incidentally doesn't have the First Amendment, came to a contradictory finding regarding statements in which Amber Heard wasn't a party, and to which the judge really kind of laughed at. How much credence should we give this foreign verdict? I remember a provision in the Constitution that says something about full faith and credit between the states. I don't really remember that when it comes to the UK, though. Don't remember the full faith and credit clause with the UK. Maybe my Constitution's a little rusty. The UK proceeding was Mr. Depp's preferred forum and had more favorable burden to proof than Virginia. This is true. It did. The fact he lost is more an indictment of the UK, though. Even though the UK proceeding was against a different defendant, that's kind of important, the exact same facts regarding the abuse in question, no, they weren't the exact same facts. They were not the exact same facts. They were not. It was a different article with different statements. Different people testified about different things. It were not the same facts. The exact same facts regarding the abuse in question supported the English court's determination. It was substantially true. That's because the English court is full of crap. The UK court found Depp engaged in spousal abuse. The outcomes in the United Kingdom cannot be reconciled with the verdict of Virginia. Let me tell you how much the Court of Appeals cares about the fact that the verdict of Virginia cannot be squared with the verdict of England. Let me tell you how much they care. Imagine a field that is fallow. Look at all the fucks I give, the Virginia Appellate Court says. Look at my field. It is fallow. There is no life on it. I don't care. The Virginia Court of Appeals couldn't give two dingleberries of a shit that the United Kingdom says some shit. The Virginia courts can barely be bothered to care what any other state thinks or the federal courts think when it comes to their own state law. Virginia is very jealous of its own state law. They barely care at all what the federal government has to say about their own state law. They definitely don't care what the UK has to say. The message of this Virginia verdict to abusers is that relitigating defamation, strikes back suits in different courts until a favorable verdict can be obtained, is profitable without regard to whether an adverse outcome is obtained in the first case. Different parties, different article, different witnesses. We are not required to give comity to the UK verdict. Sucks. Oh my God, there's more argument. I thought we had come to the end. I was coming for this passionate wrap-up. End with energy. Coming with this passionate wrap-up. But no, I was deceived. I thought we had hit the end. No! No! Okay. Thank you, Salty Rolls, for becoming a member. Thank you for everyone who hits that beautiful, beautiful join button. Okay. The trial verdict is inconsistent with the First Amendment principle and precedent. Okay, this will be good. Prior to 1964, defamation actions were guided in Virginia, like most jurisdictions, solely by common law. After the United States issued its decision in Sullivan, Virginia courts have been required to factor in the interests of the First Amendment in defamation, especially those involving public figures and matters of public concern. This lawsuit involves both. Amici are concerned that the threat of frivolous and expensive lawsuits by claimant is significant and increasing, especially in Virginia. Because Virginia is perceived to have overly favorable defamation law for claimants, many claimants, such as former Congressman Devin Nunes, have attempted to file defamation actions in Commonwealth courts that would not likely survive a motion in other jurisdictions. Let me tell you how much Virginia cares about whether or not it would pass a threshold under some other state's law. Virginia is required to give force and effect to other states' verdicts. But let me tell you how much they care as to whether or not it would pass a threshold in some other state's law. Virginia doesn't care. Virginia makes you take the bar exam in suit and tie. This is because they want you to know that they are 400 years old. We had a colony, don't you know, in Jamestown. We're 400 years old. We're an elite. We're not like the other states. We had one of the first colonies ever landed on our shores, man. The Pilgrims, they came to Virginia, man. We've been around 400 years. Our state is best state. Other states can suck it. Virginia is very elitist, or is very jealous of its own state laws. Virginia does not really care very much what other states think about really much of anything. Because we've been around 400 years. We had Jamestown. People, especially those who have been victims of abuse, are afraid from speaking out those against who have more power and money. The current case has exasperated that fear with its precedent. Experts in abuse have already seen real-world chilling effects on women coming forward with abuse. Apparently, they cite a paper called Chilling Effect. Even before the verdict in this case, First Amendment advocates expressed concerns that these suits, frivolous or not, take their financial and emotional toll. Since she says, okay, hear me out, Congress can regulate abuse in the civil context because controlling partners' income precludes them from participating in interstate commerce. Stop. Please stop writing, says she. Please stop. Please stop. No. La 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 la. No. Stop. Stop. These suits, frivolous or not, take their financial and emotional toll on defendants, even if they ultimately win, especially when those defendants aren't the New York Times. In reality, it's suit or threat to silence and harass critics by forcing them to spend money to fight baseless sets. Ricardo says, well, the Pilgrims were supposed to go to Virginia. I know, right? So, yeah. Money to defend a baseless lawsuit, something that's intended to intimidate, not win. Someone faced with a slap action generally ends up agreeing to retract their statements, apologize, or refrain from further comment on the matter in order to stay out of court. Yeah, okay. Just trying to let my brain heal for a second. Yeah. I'm sorry. Where was I? I lost the thread there for a second. I think my brain reset. Okay. According to Ken Goldberg, slap lawsuits pose threat by intimidation. See also at least a leader, a slap in the face of free speech, protecting survivors' rights to speak up in Me Too. A New York decision accurately assessed the problem when it was dismissed a defamation claim by an accused abuser. Holding a lower court's decision to allow the claim to proceed has the effect of emboldening sexual assaulters who seeks to weaponize the legal system in order to silence their victims. Well, first of all, it's New York, not Virginia. Second of all, I can't speak to that particular case. Maybe that was the right decision in that particular case. I don't know. Every case has to be decided on its own merits. Maybe that particular abuser should not have been allowed to use the court system. Maybe he was engaged in lawfare. I don't know. I'd actually have to get into it and actually do the analysis like a competent lawyer. As the court has noted, the New York court, mind you, sexual assault victims remain vastly underreported, primarily due to victims' fear of retaliation. It does not escape us the defamation suits, like the instant one, may constitute a form of retaliation against those with courage to speak. Most victims cannot afford years of litigation, nor do they wish to have their personal information disclosed through invasive discovery or relive their personal trauma through litigation, including depositions, filings, and testimony. They do not wish to endure continued unwanted interactions with the person alleged to have assaulted them through the litigation process. Well, if they're liars, though, they have it coming to them. The trial court should have ruled that Ms. Heard's op-ed was protected speech. Oh my God, why is this article? We have A, and now we have 1, and now we have 1A. There's 30 pages of this? There's 30 pages more of this? Ms. Heard's op-ed was protected opinion. Amicus believed this court should not hold as a matter of law the opinion of the editorial drafted by Ms. Heard was opinion, written to address the problem of retaliation in Hollywood when women speak out about men who abuse their power to harass and assault women. The point of the op-ed was to illustrate the problem and encourage advocacy for political and social reform. Ms. Heard wrote about having suffered abuse at an early age, including being harassed and sexually assaulted by the time she was of college age, long before she met Mr. Depp. Wait till I notice the footnotes. Okay. What footnotes? I've been reading some of what footnotes are there? What nightmare am I reading? Generally, a statement of opinion relating to matters of public concern which do not contain a provably false factual connotation will receive full constitutional protection, not be considered defamation. Pure expressions of opinion, not amounting to fighting words cannot be the basis for an action of defamation. Pure. But if they're mixed opinions, fact, the First Amendment to the Constitution and Article 1, Section 12 of the Constitution of Virginia protect the right of the people to teach, preach, write, or speak any such opinion, however ill-advised, without inhibition by actions for libel or slander. One of our most important Virginia founding fathers explained, error of opinion may be tolerated when reason is left to combat it. Well, if that's the standard, then I'm not even sure Ms. Heard's opinion are protected, because I think reason long ago left the building. So if opinion is only protected to the extent that reason is involved, then I guess we have to reconsider the immunity of opinion as an absolute principle. Because I think some opinions are not based on reason. I can't think of any opinions, for example, that are not based on reason right now, but In evaluating defamation, courts must consider the general tenor of the publication, not just the specific words out of context. That is correct. That is very, very correct. Very correct. Defamation must be understood its entire context. The context is the article, which is incidentally the judge refusing to admit the article that the claims against Depp were based on is an error. That's fourth issue in Johnny Depp's brief. I agree it's an error. Fourth issue is good issue. First issue is best issue. Issues 2 and 3 kind of suck. Issue 1 was Waldman can't be held responsible because he's an agent. I forget what issues 2 and 3 were. And issue 4 was you forgot to admit the article. Johnny Depp has 2 winners. It remains to be seen if Amber Heard has any winners. I really appreciate this comment that says, just caught you live. Wow, you get better every day. Thank you very, very much. I really, really appreciate that. I really, really appreciate that. It is validating and encouraging to know that I'm making progress, both for technical reasons, because I'm just getting better flat out because I'm doing it more, and also that my mental health is an increasingly better place. I really do appreciate comments like this very, very much. I saw a similar comment in the YouTube comments, or maybe it was it was either in the chat or the comments yesterday, which was saying a similar thing, that I'm loosening up a lot more and that I'm a lot less rigid and a lot more able to take things on. And I really, really appreciate everyone who's been here a part of the journey. And the last 4 months have been really, really encouraging. I really thank you all for your participation and love. And I appreciate those of you who were here before the last 4 months, especially those of you who are longtime watchers and had to see me go through years of downslope. That, I'm sure, was not easy for many of you who have been with me for years and had to watch me getting worse every day. And I appreciate those of you who were sticking with me, even as my mental health was getting worse, the depression was getting worse. And I appreciate all of you who recognize it's getting better. It's very, very validating. Thank you. It's very, very validating. And I still have ways to go. You know, I've said this before and I'll say it again, you know, lest anyone misunderstand me. I am not claiming to be 100% better. I am not claiming it is all fixed. I am not claiming that there won't be regress. I am not claiming I won't have bad days or bad weeks. I'm not claiming that how much more time I will need to get better. But it's validating to know that I'm generally heading in the right direction. Thank you. Generally heading in the right direction is a plus. Thank you. Thank you very much, Michelle. In evaluating defamation, courts must consider the general tenor of the publication, not just the specific words. Generally, statements that are relative in nature and depend largely upon the speaker's viewpoints are expressions of opinion. Whether a statement is opinion or fact, I live in Austin. I'm just visiting my parents right now, Mr. Sniffles. I'm just visiting my parents. I'll be here for a couple days. I'm having a good time visiting my parents for the holidays. I wish my microphone was working. I wish my laptop was working. But I've borrowed my dad's laptop and we're making do. I could stream from my iPod, I guess. I can get the microphone in that way. Maybe not. Well, then I can't get documents on screen. That's the only problem by using my iPad. Anyways. Whether a statement is opinion or fact requires the court to evaluate whether a statement can be proven to have false connotation. In the present case, the trial court erred in its analysis and evaluation of the nature of these alleged implicit statements. Although every fair inference must be drawn in favor of the plaintiff in determining whether the words and statements complained of in this case are reasonably capable of the meaning ascribed to them by the alleged innuendo, yes, everything must be interpreted in light of the verdict. That's the right standard. Meaning of the alleged defamatory language cannot, by innuendo, be extended beyond its ordinary and common acceptation. The province of innuendo is to show how the words used are defamatory and how they relate to plaintiff. But it cannot be used, thank you, Toadette, for becoming a member. That's very, very kind of you. But it cannot be used to introduce new matter, nor extend the meaning of words used, or make certain facts that are uncertain. My microphone sounds fine. No reason to push it my lungs to the limit. Well, I'm using my webcam mic because my lavalier mic is not using, and the webcam mic is not as good. So I have to project more so that so it will pick up the volume more and not sound like absolute complete garbage. So I'm fighting technical problems by speaking really loudly. Yeah. Oh, yeah. As any matter that can be considered in evaluating the statements must be within the publication itself or within the public's knowledge of the immediate past. Laura in Alessa says you sound fine to me. That's because I'm projecting. Ms. Heard's opinion editorial focused on treatment that women who spoke out regarding abuse received from the public. The op-ed taken on its face and improper context was not an attack on Mr. Depp, but an indictment of society in general, and Hollywood in particular, for not supporting women who spoke up about wide-ranging abuses. Because the statements by Ms. Heard in that op-ed did not contain a provably false factual connotation, and were not fighting words, but were pure expressions of opinion, they should not have been considered by the trial court or this court as defamatory. Were it to be otherwise, the precedent would have profound effects on amici and their ability to opine on prominent issues of the day. You can have opinions, just don't make up facts. Don't make up lies. At least my webcam is working. So I got that going for me. And it's not a bad webcam. So, you know. To affirm the verdict in this case is to chill the First Amendment right to express one's opinion, is it? And to encourage frivolous defamation claims based upon what a claimant can imply from what's spoken rather than actual words of the speaker. So you don't really like defamation by implication as a legal theory. I believe some states have gotten rid of defamation by implication. Virginia most decidedly has not, and they're not going to now. At least I'm 1080p. Yeah. At least I'm 1080p. I got that going for me. 1080p. And yeah. Taken in context, the two statements contained in the op-ed that were actually written by Heard, which do not mention Depp, are merely a summary of opinion and views regarding her life experience. Abuse in the op-ed was a subjective perspective. Was it? It was subjective? Thor Theo gives €2 to say grounds. What do they mean by fighting words? Fighting words is actually a legal concept in law. It is not an area that is protected by First Amendment. You can't. The words that would inflame someone to immediate violence are not protected, for lack of a better description. That being said, fighting words is a bit of a, what would you say? It is degraded doctrine. It's still good law, very technically, but it is not widely recognized in courts. Or more to the point, it's very narrow. It's very narrow in courts is a better way to put it. So there's not much of fighting words left, but fighting words are not protected by the First Amendment. What encompasses fighting words is very narrow, almost to the point of non-existence, but that's what they mean by fighting words. It is a technical legal concept. Antiquated. It's a bit antiquated. Yeah. Inciting. Yeah. Inciting or fighting words. Yeah. You got the idea. Laura says you appreciate the explanation. My European showing. No problem. I'm happy to help. We're happy to help the Europeans too. Ms. Heard's references to abuse and domestic abuse are subjective opinions, not a verifiable fact that could be defamatory. Wow. Okay, let's give that a shot. Demonstrating the op-ed contained only opinion, Ms. Heard only used vague and undefined terms, abuse and domestic abuse. In the two contested non-headline statements, and in neither instance mentioned DEP. Wow. Abuse as a statement of opinion. That's a neat one. I mean, I guess you got to fight every match, but damn. These statements represented her viewpoint regarding her experience. Well, I suppose that is one way the jury could parse it. That is one way a jury could parse it. They could view it that way. They just didn't. In both cases, the op-ed contained Heard's true opinion as an advocate speaking out against domestic abuse. The term abuse, as used by Heard, is subjective. It's in the eyes of the opinion of the person who's been subjected to a wide range of conduct and not subject to a clear, true, false analysis. Oh, that's good news. So now if I say I've been abused, I can't be wrong. Chat, you've abused me. You should all feel shamed. During the trial, there was uncontroverted evidence regarding actions by Mr. Depp that constitute abuse from the perspective of any woman. Wait, which one is it? Which one is it? Which one is it? Is the term abuse subjective? That is, the opinion in the eye of the beholder. Or is it the perspective of any woman? Is it subjective? Is it subjective, the opinion in the eye of the person who's been subjected to the wide-ranging conduct? Or is it the perspective of any woman? Which one is it? Is it subjective or is it objective? The perspective of any woman would be objective. Is it subjective or is it objective? All opinions are subjective by definition? Apparently not. Apparently not. Apparently, there are opinions that are objective because apparently it would be true from the perspective of any woman, which would necessarily make it objective. So apparently there are some opinions that are objective. Okay. For example, a video showing Mr. Depp storming through the couple's kitchen in a drunken rage, swearing at Miss Heard, and in that uncontested video, Mr. Depp expressed severe anger at Heard for an alleged transgression by, in Depp's own words, assaulting kitchen cabinets, with kicking and slamming, and then confronts her when he sees that she's videotaped the incident. Yeah, it seems like she was setting him up, doesn't it? She threatened Miss Heard with, "I'll show you crazy," picked up her phone and slammed it down, ending the taping. No, Miss Heard ran to the other room and then stopped the taping. Other uncontested examples of abuse, which I don't know if this is subjective or objective anymore, include Mr. Depp admits to having punched a bathroom sconce during an argument with Heard in the Hickville trailer incident, which caused her intimidation and apprehension of injury from displaced anger of destroying property turning towards her. Mr. Depp told Miss Heard to shut up, fat ass, when she complained that she had put out a cigarette on her in apprehension of injury. Mr. Depp called Heard an effing C word during a dispute with Heard. I'm gonna go with the premise it's not abuse if it's true. New posit. It's not abuse if it's true. Mr. Depp sent Heard text lambasting her while she was at a coffee meeting, saying the meeting was for whores. Mr. Depp wrote incoherent, sexually harassing messages attacking Miss Heard on mirrors, walls, and lampshades, while causing $70,000 worth of property damage. Mr. Depp admitted that he wrote, "She loves Naked Hollywood," and "Billy Bob and Easy Amber," while stating that he knew she did not want to be objectified in that way. I mean, what can you say, really? What can you say, really? Mr. Depp accused Miss Heard of bitching and called her an effing pain in the ass and a C word, while accusing her of having a goddamn effing lover. Mr. Depp called Miss Heard a stupid F during another dispute. Facts. Mr. Depp's bodyguard admitted to Depp rearranging Miss Heard's closet by pulling all the clothes off the rack and throwing them on the floor. "I threw it on the ground. All the clothes, too. They won't be part of the system. Clothes-wearing woman." During the trial, an audio tape was played for Depp. "Mr. Depp, I headbutted you and you're effing Miss Heard. I can't believe you did that." Mr. Depp, forehead. "That doesn't break a nose." Lol. Mr. Depp was asked about this interaction and admitted he said those words. In a follow-up question, Mr. Depp asserted it was not an intentional headbutt. Yeah. Although Mr. Depp claims that he did not intentionally headbutt Miss Heard, under Virginia law, Depp's testimony was an admission by Depp that he abused Heard. No, that's not true. That is not true. It's an admission of an unintentional headbutt. That is not an admission of abuse. That's some bullshit. That's some bullshit. His statement at trial that the headbutt was not intentional reiterated that he did headbutt Heard. The definition of family abuse under Virginia's juvenile and domestic relations statutes does not require intent or willfulness. It does not matter if the headbutt was or was not intentional to be abuse. Moreover, given as clear, Heard considers the headbutt to be intentional, that's not actual malice. That seems like some bullshit. That seems like some bullshit. I have a feeling we're misquoting Virginia law. Let me just pull that up real fast. Talk amongst yourselves. Let's see. VA code 16. What is this? 1228. Apparently, it's been very Googled recently. Okay. Let's see. Definitions. Okay. Let's see. I'm going to read this to you so I don't have to put it up on screen. Let's see. 16.1.228. As used in this chapter, unless context requires a different meaning, abused or neglected child means a child. Well, I can stop reading. Adoptive home means something. Adult means person 18 or older. These are definitions. Ancillary crimes means any delinquent act committed by a juvenile. Juvenile means under 18. Child in need of services means kind of what you need mean. Child in need of services. Child welfare agency. Juvenile court, delinquency act, delinquent child, Department of Service, driver's license, family abuse. Okay, family abuse. Family abuse means any act involving violence, force, or threat that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury, and that is committed by a person against such person's family or household member. Such act includes but does not limit to any forceful detention, stalking, criminal sexual assault in violation of law, or any criminal offense that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury. I don't think so, Tim. I don't think so, Tim. But nice try. Nice try. It has to place one in reasonable apprehension of death, sexual assault, or bodily injury. And the example suggests something a little bit more than maybe a headbutt. Lol. Lawyers misquoting the law? Oh my word. An analogous situation was issued in Fairfax versus CBS, in which Virginia's then lieutenant governor sued a television network based upon its interviews with women who alleged that he had raped them many years before they announced their allegations. Mr. Fairfax also complained about sympathetic comments by the co-host of CBS's morning shows after the interview was aired. The federal court granted the motion to dismiss the defamation claims in that case, explaining that the relied upon commentary, when read in context, does not ascribe to any particular view of the underlying events, but rather how persons who believe they are victims of abuse are affected. The exact same words could be said of the op-ed by Heard. The crux of the op-ed was not to rehash the allegations that Heard had previously made regarding Depp's conduct, but rather express Ms. Heard's experience after she made those allegations. I could actually see some Virginia judges actually buying this argument. That's what's really sad. I could actually see some judges buying this argument. Some woke judges buying this. I could see this actually working. That's sad. Rob mentioned the law does not extend to the circuit court trial courts. That too, because it's part of family law, which would be in family courts. So also that. So fair point. Yes. That would be the definition for family courts. So fair enough. Yeah, Rob's right. It's not in the right context. So I bet Rob had a lot of fun with this brief. I might have to go watch him after I'm done with this. Did Rob lose his sanity? Is he okay? In the arms of an angel. At no times in the op-ed did Miss Heard talk about the specifics of any alleged abuse by Depp, even without mentioning his name, but rather she talked about the effect of coming forth as an advocate for women who have been exposed to abuse. Well, that's certainly one interpretation, but that is the legally required interpretation against the jury's verdict, which found not those things. Rob is still recovering. He was slumped under his desk. In fact, you feel the urge to give money to the ASPCA? Instead of giving money to the ASPCA, may I encourage you to give money to an Uncivil Law. An Uncivil Law also would appreciate your kind, thoughtful donations. Far away from here. Yes, with your donations, Uncivil Law can continue to thrive and become better and stuff. Any enemy that you fear, oh yeah. Rakita and Good Logic were the ones that burned their lids? Okay, I'll definitely have to check that out too. Who's Rob? Rob is Law and Lumber. Rob is Law and Lumber. Rob is also a good guy. In the op-ed, Miss Heard used the term abuse to summarize her experience, not as a reference to any specific event. Well, that's kind of up for the jury to determine what it means. Thanks very much. Looking at this, anytime a person would publish a comment about a topic, not a specific incident regarding that topic, such as discrimination or suppression, numerous claimants may mistake or interpret the mention of the overall topic for a specific allegation and bring a lawsuit. It's possible, depending on the rest of the context of the article, specifically if you say 2 years ago, that might do the trick. If this type of defamation is permitted to state a valid claim in Virginia, Virginia courts, Virginia newspapers, television statements, commentators, and citizens will be severely limited in their ability to speak about important matters facing Virginians on a wide range of issues, not just abuse, such as those discussed in the op-ed, but also racial discrimination, issues involving the suppression of political speech, and other issues involving debate. Yeah. As the trial and subsequent comments of the jury illustrate, the term abuse is one that's As the trial and subjective comments of the jury illustrate, the term abuse is one that's subjective and open to interpretation depending on one's vantage point. Wow. I wasn't expecting a comedy show, man. Shit. Dude, this is hilarious. Amicus maintained that as a matter of law, the term abuse in the op-ed not reasonably capable of the defamatory meaning that Depp ascribes, but rather is Heard's subjective opinions. I'll tell you what, man. 10 out of 10 for effort. No joke. 10 out of 10 for effort. No joke. I mean, I appreciate it as a lawyer. I appreciate it as an advocate. They really went for it. And, so they could actually get a judge to buy it, which is disappointing and sad, but probably true. Fairfax is kind of woke. Fairfax is right bordering DC. So some of these judges might be a little woke. So you might get an appellate judge to actually buy this, which is really disappointing, but possible. But, I mean, it is very well written, and it's actually fairly persuasive. I think it's crap. I think it's bullocks, but I have to appreciate talent where talent lies. Have to give the devil their due. They sung a good song. The song is shit, but also it was hilarious. I appreciate it in a sort of a Machiavellian sort of way. The alleged abuse defamation was not based upon facts that were verifiable. Oh, well, how would we get facts? However would we get facts in a courtroom? In reviewing a publication to determine whether it's defamatory, a reviewing court must consider the entire published statement, not just an excerpt out of context. As I said, yes, that's true. The entire article must be understood in its own terms, which is why the headline is also relevant. The Federal District Court in Fairfax versus CBS achieved the correct balance by reviewing the entire publication and the alleged defamatory passages in context rather than focusing on certain passages and consistent with Virginia precedent. A recent decision from the Western District of Kentucky regarding another highly publicized incident is instructive. Citing Sandman versus New York Times. How exciting. Bring Nicholas Sandman into this. In that case, a student wearing a MAGA hat stood in front of an older Native American man while later attempted to go to the Lincoln Memorial to engage in a tribal ritual. After the incident, Phillips was quoted by a newspaper saying, "Sandman just blocked my way and wouldn't allow me to retreat. The plaintiff initially filed a case against several news organizations on several grounds, but the court dismissed all other claims, narrowing the issue to whether the court's publication of the discrete quote was defamatory. In analyzing the question, the Kentucky federal court applied Kentucky state law on defamation. Holding the statement is not defamatory, the court concluded Phillips' statements that Salmon blocked him and wouldn't allow him to retreat were objectively unverifiable and thus non-actionable opinions. Instead, a reasonable reader would understand that Phillips was simply conveying his view about the situation. The court further explained that generally blocking is an imprecise term capable of different meanings that lacks a plausible meaning of verification. I mean, I got to give him credit where credit is due. I got to give the devil where the devil is due. It's like blocking is an imprecise term and abuse is also an imprecise term. So therefore, the jury can't define it. Also, I think incidentally, the court made a mistake here. But, hey, it's law. So good on them. Here is Sandman. The words abuse is an imprecise term capable of different meanings that lacks a plausible meaning of verification. I like how this kind of contradicts their earlier arguments. I like how this kind of contradicts their earlier arguments. Because earlier they were all like, abuse means everything. Abuse means physical, psychological, religious, telepathy, thoughts, fleeting images, right? Abuse means all the things. And now they're like, oh, abuse is just opinion. We've cited these courts from Virginia's domestic relations court, and now it's just a pure opinion. It means anything anyone wants it to mean. It doesn't mean anything. Abuse literally means nothing. So they want the appellate court. They literally are in the position where they're asking the appellate court to declare that the term abuse means nothing. It's a strange time we live in, friends. It's a strange time we live in. That seems to contradict a lot of what they said earlier. But now they want the Virginia appellate court to say the term abuse is pure opinion. It doesn't mean anything. It's a fugazi. In the present case, Damp's counsel focused on just a few words and then merged those comments out of context with statements and act that occurred more than 2 years before. Yeah, because, of Heard saying 2 years before. That was kind of the reason why. Statements in the op-ed cannot be the basis of finding actual malice. Well, that's probably true. But we don't need it to come from the op-ed. It's a separate element of the tort. We don't need it to come from the op-ed. I mean, it can, but it doesn't have to. In order to find a person liable for defamation when matter at issue, as here involves a public figure, a claimant must establish clear and convincing evidence of actual malice, which requires the plaintiff to show that the defendant knew the publication to be false or evidence reckless disregard. Knew to be false is your trigger here. If the op-ed is understood to convey grotesque physical violence, then Heard knew that wasn't true. While there may be a debate, what? I'm so confused right now. While there may be a debate as to whether the word abuse is verifiable fact or opinion, see below. Are they going to contradict themselves? Having just said its opinion, are they now going to turn around and say it's fact? Please tell me they're not going to do that. They already said it earlier, but please tell me they're not going to, in the same breath, say it's both opinion and also not opinion. I don't think my poor brain can take it. People are saying yes. No, they can't be that stupid. No, it's not possible. No. All you guys in chat are lying to me. I don't know why you're lying to me. Why are you lying to me? They can't possibly have done that. Okay. Chat, just in case I don't make it, and I die, I want you to know it's been an honor streaming with you. While there may be a debate as to whether the word abuse is a verifiable fact or an opinion, in the present case, there was unrefuted evidence that Mr. Depp engaged in actions that could be considered abusive to Miss Heard under any reasonable definition of the term. Thus, as a matter of law, the trial court should have held, and this court must hold, that Heard's statements about abuse were legitimate, subjective articulation of her perspective, and that cannot be constituted actual malice in any defamation analysis. Based upon the objective, uncontested evidence of actions described above that can only be considered abusive, the alleged interpretation of Ms. Heard's statement that Depp has engaged in abuse and domestic abuse were reasonable and could not have been found by a reasonable jury as uttered in actual malice under Sullivan. As a result, these defamation claims should have and must now be dismissed. Point 3. No defamatory facts could reasonably be implied in the op-ed written by Heard. In considering a claim of defamation by implication, the question is whether the article is reasonably capable of defamatory meaning to which the claimant ascribes to it, and is a legal issue for resolution of the court in its gatekeeping function. That's true, fair enough. Where statements of fact are literally true, but by an implication arising from them are alleged to be false, the alleged implication must be reasonably drawn from the words actually used. Also true. To be defamatory, a statement must be based upon the reasonable interpretation of the statement. Yes, fair. That's true. In the present case, the statements made by Heard were on their face true. First, Heard did become a public figure representing domestic abusers who eventually spoke out on behalf of the ACLU about abuse and eventually speaking out on behalf of the ACLU about sexual abuse and domestic violence. For this advocacy, she was subject to several severely adverse responses. Second, Heard has seen that institutions provide protection to men who've been accused of abuse. Third, as an individual and later as an ACLU representative, she spoke up about sexual violence and received negative responses and further believes this should be changed. There was no mention of Heard's marriage to Depp or any mention of him in the op-ed. Nonetheless, Depp alleges that each of these statements were defamatory by implication. Depp asserts that these statements are of and concerning Depp, as he is Miss Heard's former husband, and she's publicly and falsely accused him of domestic violence in 2016. Moreover, Heard intended to refer to Depp in these statements, which we now know to be true, and those who know Depp or read sexual violence understood the statements to be about Depp. Depp further claimed that these statements, which imply that Heard was the victim of domestic violence at the hands of Depp, are false. There's no temporal relationship between allegations of abuse by Heard with the resulting publicity in the op-ed. Yes, there is. She said 2 years ago. That's a temporal reference. 2 years is a temporal reference. How do you think time works? The court allowed these claims to move forward despite the fact that the information that Depp used to establish the implications were made when Heard obtained a temporary restraining order over 2 years prior to the op-ed being published. Moreover, there was no evidence presented in the Washington Post, the forum for the op-ed, that had ever published any of the statements relied upon to flesh out the defamatory defamation. There was no evidence the Washington Post had previously published articles about the allegations that were protected in 2016 beyond the limitations in any time. There can be no implication that readers of the op-ed would have any reasonable basis to assume these facts. These facially true and unrelated comments were about Depp. Depp stretches the meanings of the word used by Heard beyond their normal meaning and reasonable construction in the op-ed. Republication of the headline written by the Washington Post staffer cannot be the basis for liability. Why not? Although the Supreme Court of Virginia has not formally addressed the issue, amicus believes the Fourth Circuit is correct, that Virginia would follow the great majority of states that now follow the single publication rule. Under single publication rule, a statement made on a website is not republished unless the statement itself is substantially altered or added to, or the website is directed to a new audience. We've covered this before. A mere hyperlink without more cannot constitute republication. It's a good thing there was more then, wasn't there? It is uncontested that the Washington Post staffer wrote the headline, Amber Heard, I spoke up against sexual violence and face her culture's wrath, that has to change, or that Miss Heard did not participate in the creation of the headline. So it's uncontested, it's this or this. So it's contested. It's uncontroversial that Heard sent out a tweet, a message on a social media platform, Twitter, forwarding an online copy of her article to her followers on the platform without adopting or addressing the heading. I'm not so sure about that one. Nonetheless, in the verdict, not only found that she was liable for the headline, but republication was with actual malice. In the present case, the facts are not sufficient to establish that Miss Heard's lone tweet was republication, for which she could be held liable in defamation as it did not alter the headline, did not add to the headline, nor to discuss the headline in any manner. Mr. Depp provided no causal connection between the op-ed and any alleged injury. Damages are not normally awarded where they're uncertain, contingent, or speculative. Likewise, causation must be established in order to support defamation. Given that Depp was awarded $10 million in compensation by the jury, due process requires some basis for such an award. If large claims for defamation can be awarded in the absence of evidence of causation, media organizations across the Commonwealth have good reason to shut down their editorial and news departments in fear of such an enormous verdict, or, just don't spread lies. Mr. Depp's counsel presented a distorted view of whether the op-ed actually caused harm to Depp. There's no evidence that any Hollywood or other movie exec relied upon Heard's vague references to her being ostracized for becoming a public figure representing domestic abuse to deny Depp any role. On the contrary, there were numerous prior publications demonstrating the risks and dangers of employing Depp. In fact, although Depp asserted that most of the damages from the op-ed were the result of Disney refusing to hire him for Pirates of the Caribbean 6, Disney's corporate designee testified that Disney had found no copies of the op-ed or emails discussing the op-ed in its files. There can be little doubt that Depp's reputation and actions were well known long before the publication of the op-ed. Woo. It is also alarming the verdict was allowed to stand given the utter lack of causation evidence showing this one op-ed was the source of Depp's financial troubles, especially since given Depp's previous unsuccessful defamation suit regarding statements from the English newspaper The Sun in another court. Depp's counsel in the case claimed that the wife-beater assertion in the Sun article was reputation-destroying, career-ending allegation. How could anything said by innuendo by Depp have damaged Depp? Anything said by her damaged Depp if his reputation already been destroyed and his career ended when the Sun published? Well, it could be in the UK specifically. And also, maybe the jury thought that that lawyer was wrong. Because the juror is the finder of fact. Even if I go up and say, okay, his reputation was totally ruined, the jury can be like, nah, man, you're wrong, dude. Because the jury is the finder of fact. If I, as the lawyer, say Depp's reputation was entirely harmed by the Sun article, I am suggesting a fact. But the jury's the finder of fact, so they can disagree with me. It's understandable the jury was misled into believing there was such a connection between the charges and Depp's career trajectory and Heard's previous statements, given that the jury was not permitted to see evidence of other publication. Oh my God. I see in D. I see the word comedy. I see in section D, I see the word comedy. Hold me. Fine. The trial court should have dismissed this action based on comedy. Fine. In addition to First Amendment concerns regarding the verdict, there is reason for amici to be concerned that the trial court gave short shift to the UK High Court decision, finding it was substantially true that Mr. Depp engaged in spousal abuse, causing her to suffer significant injury on an occasion, leading her to fear for her life. Thank you, Magic Monster. That's a very nice comment in chat. That's very nice. The passion is why you're going through this for the fourth time. This is why it makes me brilliant. Thank you. Thank you. I appreciate the love. Let me see some cowboy hats and orange hearts, baby. Let me see some cowboy hats and orange hearts, man. I can use a little pick-me-up. But thank you for the love. The UK court further found abuse to have sexual dimensions and prodigious amounts of property damage. Comity is honoring the other court's verdict. It's full faith and credit. Full faith and credit is comedy. It is adoption. It is deference. It's full faith and credit. That's comedy. The UK court further found the abuse to have sexual dimensions and prodigious amounts of property damage caused during a jealous sexual accusation in a non-contact sexual violence. This is a good sentence here. Prodigious amounts of property damage caused during jealous sexual accusations in a non-contact sexual violence against Heard, which created a probable balance for sexual assault. The Fairfax court held that the libel laws of Virginia are starkly different from those of England. The Declaration and the First Amendment, yeah, there's that pesky thing. There's that pesky thing. The Declaration of Independence. Shut up. I don't need premium. I don't need to move words around. The Declaration of Independence and the First Amendment of the Constitution represent major departures from English common law with respect to freedom of speech and freedom of the press. This is illogical, given that any First Amendment protections implicated by the alleged defamatory in the op-ed would have protected Heard speech, not Depp's interest. And then they say how the Declaration of Independence affects the party's legal interest regarding defamation is a mystery to amici. Maybe it's that we're a different country. Maybe that's the idea, that we're just a different country. Maybe that was what the court was talking about when it was talking about comedy. Hey, the United States is different. Virginia is not part of England anymore. Don't you know? The considerations regarding comedy and UK judgment support application in the present case. In the current age, when a fact is published in one form, it is often picked up and republished in various other media. A claimant should not be able to sue one publisher in one jurisdiction, lose, and then sue another publisher regarding the exact same facts in another jurisdiction, hoping to get a better result. Why not? Different places have different laws. They're different publishers and different facts. While there might be exceptions to this rule, such as jurisdictions in which the rule of law is not given the same respect as that in the Commonwealth, here Mr. Depp got a second bite at the apple on the very same facts upon which he already lost a case in England. What is more galling is that Depp was one who filed the UK action and the one who chose to litigate the case first, relying on the more favorable standard of review. When he lost in the UK, that decision should have shut down any further actions based on the same facts. The trial in this case was not about any defamatory statements made by Heard within the op-ed, but rather was a vendetta for all publicity surrounding the allegations of abuse by Depp from the date that Heard sought and obtained a restraining order. A defamation lawsuit based upon this op-ed was not the legitimate vehicle for remedying Mr. Depp's dissatisfaction with how his career developed, how his marriage ended, and how the negative publicity has reached much of it warranted by his own actions, as evidence would have shown. Blaming the victim. They're literally blaming the victim. Holy God. He cannot seek retribution for the allegations that were made in California courts regarding alleged physical abuse of Heard, their divorce, and subsequent publicity. Defamation by implication is a limited doctrine that does not allow a litigant to rehash dissatisfaction with his public coverage from years ago and from all sources. The doctrine further does not allow the claimant to twist the meaning of words in publication that's alleged to be defamatory. When evidence establishes defamation has a subjective basis, Considering vantage point for the statements made, actual malice cannot be reasonably found. The damage will be done if this verdict is upheld to First Amendment jurisprudence, the ability of Virginians to express their opinions, and the ability of women to report domestic violence for fear of retribution, and an expensive lawsuit would be no less than catastrophic. For these reasons, amici respectfully request this honorable court reverse judgment. Respectfully submitted, certificate of service. It's over. It's over. I'm free. I'm free. I'm free. I didn't die. It took me 3 hours. Okay. For the 605 of you who are still here, by the way, thank you for being here. Have you hit the like button? The like button is free. It costs you nothing. And if you're still here, you must have found some value in it. So, if you'd like to help contribute financially, you can do so for a mere 99 cents. For 99 cents, you can support Uncivil Law. It's true. Merely by clicking the join button or clicking the link or whatever, you can help join the channel and help the channel grow and provide support for the channel and stuff. And, things and all the rest of it. Also check your subscribe button. Make sure that you're still subscribed. Yeah. So make sure to do all those things. Thank you for all the people who super chatted and gave memberships throughout the stream. I appreciate it as always. I'm going to have a beer now, some lunch. I'll be home again in a couple days. Thank you, Dragonstar, for the New Zealand $10. I appreciate that. This is well, I'll say this for it. I'll say this for it. They got their money's worth out of this attorney. So while I think this attorney is saying some bullshit, I think this attorney is a very good attorney. He's apparently from the firm of Fletcher, Hurld, and Hildreth in Arlington. And you know what? I think he wrote a very good brief. I think it's bullshit, but I think it was well written. And I think there's something here that a woke judge could definitely cling on to. I don't think they should, but $5 from Red Guy. In addition to abuse standard being the wrong court, the standard specifically does not include accidental incidents. Yeah. So I think that there's some chance that this could influence somebody. I think this was masterfully written. I don't think I could write this well, actually. So I have a lot of respect for this attorney. I don't think I can write this well. It's a lot of bullshit, but they did a lot with not much, and I respect that. So I respect this attorney. They got their money's worth out of this attorney, even more so than the other amicus brief. This is really, really nice legal writing. It unfortunately drives me insane because it's incredibly twisting of the facts and law, and like crap, and should be ignored. But it's well written. So I think they stand a chance. I wouldn't cite the juvenile code. I might if I thought it gave me a help. I thought if I could use it as some sort of persuasive authority that could in some way be used to help my case. I might, if I can find something that, if I can make the connection. So. All right, I'm going to sign off. Love you guys. Peace.